Now, understanding the fact that we have completed some 49 to 50, we will proceed further and go and cover the next 50. There were two topics which were repeated, so I have removed one. So the 50 has become 49. So we'll take from 50 to 100. We have not missed out anything, so no worries. When the counter offer is made, the original offer will do what? It will lapse, because you remember the dog and parrot example. I will give you parrot. Okay, I will accept, but you get my dog. Some examples we were talking about on the counter offer. So the original offer will lapse. So that's what they are trying to cover. Prospectus, very simple. I will issue prospectus. I am only inviting to the offer. You may or may not accept the offer. So I am not bothered about it, whether you are taking it to the offer or not, but this is my invitation to offer. So price list, menu card, prospectus, all these are what? Invitation to offer. Next, in telephonic conversation, the acceptance is completed when the words are heard by the offerer. I am accepting. Now you are listening to me, right? The moment when the words listened by your ears, then the acceptance is complete, is what they are talking about. Next, when the offer is made to definite person, when I am giving it to overall public, it is general offer. I am giving it only to you. So special offer. Now this video only for people who have paid, I am giving it to them, not for the general public. So special offer. Are you clear? Next, Yatra Travels operates AC buses from Mumbai to Nasik. The bus is standing at the bus stop in Mumbai, waiting for passengers traveling to Nasik, and it is ready for a departure. What does that mean? Have they made any announcement? No. No oral. Have they given anything in writing? No. So what does that mean? This is an implied offer. Implied offer means what you will have to understand. Conferred from the conduct of parties. How they wanted to conduct themselves. It is only through the action, not directly, is what they are trying to say. Are you clear? So what is the next one? Contract, where the consent of one party is obtained by undue influence, is voidable. Now listen carefully. I talked about free consent. You remember when I was talking about in the basics, the first introduction video, I was talking about free consent, consensus ad idem. Now, in that we talked about there are elements vitiating free consent. That means which is not fully, properly having a consensus ad item. Meeting the minds of people is not there. In that, there are 5. Number 1, coercion. Number 2, undue influence. Number 3, fraud. Number 4, misrepresentation. Number 5, mistake. I will again repeat. I'll again repeat. You can also write it and keep. Elements vitiating free consent. So you can also, maybe I will add something here, and I will also tell you what is this. We'll make it bigger also for you to write. Then I will make it smaller. Elements vitiating free consent. How many are there? 5 are there. What are they? Number 1, coercion. Undue influence, fraud, misrepresentation, and mistake. There are 5 things. In this, coercion, listen carefully, coercion, undue influence, misrepresentation, fraud, misrepresentation, everything is going to be voidable at the option of parties. So what they are talking about here, they are saying undue influence. Without even thinking, what you will have to say, it is what? It is voidable. It is voidable. So I'll mark here. Are we clear with this? Can you take down this? Yes, I'll mark this in green color. Elements vitiating free consent. What are the 5? Coercion, undue influence, fraud, misrepresentation, mistake. Yes, have you taken in this? Now, see the types of contracts. Here, voidable. See what I have done. Coercion, undue influence, fraud, misrepresentation. Mistake will not be there. Mistake will not be there because Indian law mistake, unilateral mistake, it will either be valid or it will be void. See, foreign law, foreign mistake. Yes. So like that. So maybe I'll mark it here in a different color. You will understand this. See, mistake. I am saying it is not voidable, but the first four is voidable. Are you understanding what I'm saying? Coercion, undue influence, fraud, misrepresentation is voidable at the option of parties. Mistake is Indian mistake, foreign law mistake, unilateral mistake, bilateral mistake. So you can accordingly try to remember that this is going to be one of the most important things. Yes, this only will confuse you. So I have already marked this and made it really strong. So you can cover this easily. Are we clear? So what I am doing, I am moving this. Then I am also marking it in bold so that you will remember it for a long time. Yes, all this only here they are covering. So the first four, yes, first four is going to be voidable. That only undue influence is going to be voidable. I'll take you through one after another. What are they? Next, a voidable contract is at the enforceable at the option of parties. We already know this. Many number of times we told. Next, A offers to sell his house to B, who agrees to purchase it subject to approval by B solicitors. That means who is taking care of B's property is solicitor. Okay, A offers to sell his house to B. Okay, who agrees to purchase it subject to the approval. Only B's solicitor is saying okay, then it is fine, which is correct. Now what they are saying, B statement is absolute but with a condition attached, qualified. So this is a very raw related concept, but still you can say I am happy but subject to approval. There is some condition attached but qualified. Not an important point to be remembered. So I am just saying it is not so important to be remembered, but still. So I am putting that in a light black color. So not a big deal to remember. Yes. For binding contract, both the parties should agree upon the same thing in the same sense. What is this called? What is this called, guys? This is called consensus ad item. We had already told this. Meeting the minds of people. Are we clear? Same thing. They ask in different words. Legal obligation means what? A duty enforceable in the court of law. Then only it becomes what? Then only it becomes contract. Are we clear? So conceptually, if you make it strong, how many number of MCQs we will not bother. Only those agreements are who are legally enforceable is called contract. We have already told. Non-fulfillment of an acceptance will obviously be lapse. What is created by situation, by not speaking or by not writing, it is called implied contract. We have already told. So the keyword you will have to underline here is situation. Yes. So here I am making it. The red color alone is keyword, so you can remember. Now, executed means what? Completed. Executory means yet to be completed. I'll again repeat. Executed means completed. Executory means yet to be completed. Executed contract. When the book seller sells a book on cash payment, that means complete. Executed contract. Are we clear? Next. Messrs. Law Book Company made an offer to sell a new law book released recently only to the members. Only to members. That means it is not for public. Only to the members of Bar Council. Are you understanding the keyword? What does that mean? Specific offer. Are we clear? So when you read itself, you will understand the concept. Match fixing. Is that legal? No, illegal. Next. H. A coolie in uniform at the railway station carried the luggage of Z, a passenger from the platform, to the taxi stand without being asked by Z to do so, and Z did not attempt to stop him. Now, I wanted to get down from the train. Suddenly, one coolie comes and takes my bag, and he is coming along with me. I did not stop him. I did not stop him. So he came to the place where the auto or the car is there available so that I can get inside and come to my home. Now I did not speak a word saying don't carry, I will not give you anything and all. You also kept quiet, that fellow also carried and come. Will you pay him or not? You will definitely pay him because you did not open up implied contract. So you are bound to make the payment. See what is the answer? In this case, yes, Z is bound to make the payment to H because I am Z here. I did not speak anything. Coolie is H. So automatically that fellow carried the bag and came. So I did not stop him. So automatically it is bound. Are you clear? I should make the payment. Next, holiday packages. Next example for invitation to offer. Agreement to put a fire. You put a fire on that fellow car. I will pay you money. Is that legal? No, that's bad. So it is illegal. Are you clear? Next, the specific offer can be accepted by to the person to whom it is made. Specifically, I am giving it only to you. So it is only to the person to whom it is made. Are you clear? Implied contract is valid? Yes, definitely valid. But we are not going to speak or write. When it is for the whole world at a large, it is called general offer or public offer. Are you clear? Yes. Contract is what? Who are competent to contract only will be there. That means what? Unsound mind, lunatic fellow, or any person discharged from the contract or disqualified will not be competent to contract. This is a quite an important point. So I'll mark this in green. The enforceability of law is valid. Yes, offer, acceptance, everything should be there. So that's not a big point to remember. So the answer is yes. Invitation to offer means what? Offer is made with an intention to have negotiation. If you want, you can get. Otherwise, you don't need to. Are we clear? Next, what is having some technical defect? Already we covered. Unenforceable contract. Agreement without consideration is valid when made. There are some points. There are some points where, like, even when there is no consideration, gift, where you wanted to give gift, will you wait for consideration? No. Even without consideration, contract is there. Gift deed, all this and all. There are some 3-4 points. Easily it will be all of these only. There is no doubt. So what are the points? We will cover that separately by way of charts and diagrams. Okay, we will take you through that. Only 1 or 2 questions will be there for chart and diagram. We can easily cover. Now that's what I'm saying. Even when there is no consideration, there can be contract. Usually we will say this: when there is no consideration, no contract. See what I'm going to write. See what I'm writing. No consideration, no contract. Correct? Is what they call this as nudum pactum. What is nudum pactum? When there is no consideration, contract is more like nude. That means what? That means it will not be having an effect. That only you should understand as a nudum pactum. Now they wanted to say it is not fulfilling. The main purpose itself is gone, but there are exceptions to nudum pactum. Nudum pactum, and there are exceptions to it. Exceptions to it means what? Even when there is no consideration, there can be contract. That's what they are saying here in the previous point. Even if there is no consideration, contract will be there. I told you gift deed. You remember? Like that. Agency. Even when there is no consideration, contract will be there. Yes, that means enforceable in the court of law. Who will have to give consideration? Promisor only should give consideration. So it should move at the desire of promisor. Are you clear? Which of the following is not an exception to the rule? No consideration, no contract. Involuntary service. I told you, no, gift deed, compensation for involuntary service. So I'm marking this in green color. Even when there is no consideration, there can be contract. Past consideration is valid only in India. That means I have already given you consideration. You work now. This has happened. This will happen only in India. So quite an important different point. Next, 80th. A is indebted to B. That means what? A should pay to B. He owes B. He should pay B. He sells a trolley to C. C promises to pay all the debts of A to B. Now C is doing on behalf of A. If C fails to pay, B has no right to sue C. Why? Because A and B only is the party to contract. C is only a stranger to contract. Are you clear? So what you should understand when you read an example, who is party to contract, who is stranger to contract? You should know that first. A, B, these two people only are parties to contract. C is only doing on behalf of A. For B, he does not know who is C because C is stranger to contract. Are you clear? Very simple point, but quite an important point. So I'll mark this in green for a safer. Next, consideration is defined under section 2 subsection D. Quite an important to remember. So I will mark this again in green. Okay. 2E, we have already told agreement. Like that, there are some 2-3 sections. If you remember that, it is enough. Okay. You don't need to remember everything. Inadequacy of consideration. Consideration is not adequate. Will it still be possible in formation of contract? Yes. For example, today I am getting an iPhone for 40,000. After 3 years, will I sell the same iPhone for 40,000? Will anybody get? Even an unsound person will not get. Correct? Because the value gets reduced. So automatically what will happen? This is called skimming pricing. Initially, they will start increasing the price and slowly it will get reduced. They call it a skimming strategy. Now the point is, still will there be contract when you give lesser amount than 40,000? Yes. They call that consideration as inadequate consideration. So still formation of contract is possible. That's what they are saying. Are you clear? Next. Rohan promises to make a gift of rupees 10,000. Now, like this, they can ask you case-based questions also. So we should answer when we know the basics really strong. Rohan promises to make a gift of 10,000 towards the repairs of temple. The trustees of the temple on the faith of his promise incurs liabilities. Rohan does not pay. Can the trustees recover the amount? Yes, definitely. He promises, so he should definitely can recover up to 10,000, not more than that. Privity of contract means what? Stranger cannot sue. Did I tell you that? But when it is trust or charge, even though when there is what they are stranger to contract, they can file a case against them. I will again repeat this to make yourself really strong. Privity of contract, stranger cannot sue the parties to contract. But there are exceptions. What does that mean? Exceptions means what now? Stranger also can sue. Are you understanding this? So in that place where there is a trust or charge, in any person who is involved relating to trust, though he is a stranger, he can sue the party if there is a problem. Are you clear? When there are exceptions, the stranger also can sue. That's the most important point. Which of the following statement is true? Consideration should obviously start from the promisor only. Very simple point we have already told. Consideration means what? Past consideration, present consideration, future consideration. Doing or abstain from doing something. That is your future consideration. See what I'm writing here. It's called future consideration. What does that mean? Doing or abstaining from doing something at the desire later. Now see this point. 86 I have marked. Immediately see 88. It can be past consideration, it can be present consideration, it can be future consideration. Are we clear? Which of the following is void? Inadequate consideration is void. Listen carefully. Inadequate consideration is void if inadequacy is not supported. I told you inadequate consideration is there. I told you about the iPhone, right? 40,000 when I wanted to get 2-3 years, I can get only for 7,000 or 8,000. Inadequate consideration is fine. But if the inadequacy is not supported by free consent, then only it becomes a void contract. Are you clear? So important point. So I'm marking it in green color. You know why I'm marking something in green color? Yes. When it is important. Next, payment of a time barred debt. Even after the time, can you pay? If that person allows, yes, it is valid. So this is going to be important point. Now this valid, no, you can go and see valid here. See what I have given here, valid. So promise to pay a time barred debt is valid. So you can update the list. There can be a stranger to consideration. Yes, I can give to anyone. That fellow is not directly helping me, but he can be a stranger to consideration. Contract of love and affection. Now, when I wanted to give something in love, will I expect anything in return? I gifted you something during the birthday. Will I expect to my birthday you will have to pay? Will there be something in return? No. For love and affection and all, there will be contract, but without consideration. Shall I give you a best example? Gift deed. Now, father is giving to the daughter or son a deed by giving a gift. Now, will the daughter or son do something in return for father because he gave the do? No. The point is love and affection. So, there is requirement of no consideration, but contract will be there. Are you clear? Yes. In case of completed gift, consideration is not required. Just now we told. And consideration, but it must be real. It should not be only in the books of accounts I gave you 10 lakh rupees, but actually it did not happen. It should be real. Stranger to a consideration can sue. I already told any stranger for a consideration can sue the other person also. Next, agreement without consideration case of natural love and affection is valid. Now only we told it is valid. When it is written and registered, it is valid. Promise to pay a time bar that we already told it is valid. Legal proceedings restricting the right. When you restrict the rights relating to the legal, that means then it is not enforceable in the court of law. Void. Next, three more we will cover. Yes, a seller of imitation jewelry sells his business to B and promises not to carry on the business in imitation jewelry and real jewelry. The agreement is valid with regard to imitation and void as real because these two people wanted to frame an agreement only to the imitation and not to the real jewelry because he's a seller of not real jewelry, only imitation jewelry. Quite an important point. So I am coloring this in green color. Are you clear? Yes. So read this point again and again, you will understand. Yes, a minor by fraudulently representing himself to be major intended to lend him what? Intended to lend him 4 lakh rupees. What is this? Yes, a minor by fraudulently, he is not actually major, but he is showing as if he is major and he refused to pay it. L sued him. Totally void because you cannot enter into a contract with minor. I'll mark this in green. Why? Minor example, they will definitely ask. Next, mistake as to foreign law is considered as a mistake of fact. You know that it is going to be there. Factually, you know that it is a mistake, and foreign law will be considered as a mistake of fact. Foreign law, Indian law, whatever it is, mistake of fact. So you can remember that this will come under free consent. Free elements vitiating free consent, coercion, undue influence, fraud, misrepresentation, and mistake. Here it is going to be majorly mistake. I already told you this to get covered. In mistake, where and all unilateral, Indian law is valid, foreign law is void. Are we clear? So this is going to be more a void contract. Are we clear with this? Now what we have done, guys, we have completed some 100 things and we will consider the next thing in the further sessions to make it really strong.